That made you time to show you hearing on it.
Good to see you. Okay, let's see, this. Yeah, it was a matter, as the court recall, when the defendant was. So placed on probation, right?
Do you know, Judge?
No.
This was a jury trial where the jury gave him 2.5 years in prison, and then
Okay.
they asked for an appeal bond. We had a hearing. You told him that if he would go get treatment, you might reconsider it. And so he went off and did treatment.
Yeah.
He
It
successfully
was a
completed
90,
this.
it was probably 90 days. So what we have is, this was based on a motion to set an appeal bond filed in December. And then the court ordered that we go to a facility for treatment and for at least 90 successive days, which it looks like that has happened.
Yes, Judge.
And there's no report or anything. Well, I guess
That's my problem with this whole thing is we don't have anything from the facility saying how he did. We just got he's out after 90 days.
Yeah, I can get something.
we,
My-
the day you did it, do it, and we'll come back.
Okay.
But we gotta get something that shows, I'd like to know, especially for setting other terms and conditions.
We may have it. Okay. As you know, I've been a little busy in here, so,
This is a perfect example of how courtroom decisions are based on documentation, not assumptions. The defense insists the defendant successfully completed treatment, but from the judge's perspective, verbal assurances aren't enough. Before modifying bond conditions, the court needs official records showing what actually happened during those 90 days. That's not just procedural formality, it's a safeguard designed to ensure accountability. Notice how the judge carefully slows the process instead of rushing to a decision. That patience can make all the difference in cases involving rehabilitation and public safety. What do you think? Should completing treatment be enough on its own, or should judges always require detailed reports before granting additional freedoms?
I don't know if you know that, but I've been busy.
you've been watching and judging. You say you emailed it to me or to Randy? Okay. Okay, so she probably.
As amusing as this is, watching you fiddle with your phone and attempt to pull out an email or a text, there is something.
There is.
You're not just typing something in right now.
Using that AI generator, are you?
Where is the
They're texting me saying it's.
appeal? What's the appeal? Have y'all filed
We filed a notice of appeal. I think we,
when's the brief due?
I don't even know that we have a briefing schedule yet, Judge.
What's the problem?
Hang on, this.
Being set for misdemeanor 4/3/27.
For his MTRP on his misdemeanor.
Yeah.
Okay, I'm looking.
Did you?
With Marvin Lewis's response.
No.
Is that one?
No, this is the dismissal, and this is the.
Oh, Lawrence.
This is the one we haven't done.
Oh,
The other one is a dismissal that I'll give you in a minute.
Lawrence.
Let you look at it. I'll look at it.
Hey, Kendall, could you tell the jury we're going to need about 10 more minutes, please, and thank them for their patience. Thank you. Is this all there is? It's a succinct, just this,
Yes, Judge.
that one paragraph?
If you,
Okay.
if you move the,
Is there more to it?
I don't know, but if you use two fingers
On the
up
screen,
and down on the mouse, no, it doesn't.
on the mouse, you have to do that way.
In the past.
You don't have a touch screen. $100 lawyer like you.
Well, no. Oh, I see. You got to move it up for it to go down.
Enter twice to exit, Judge.
I want to see how you drive a vehicle. You down Interstate 10 in reverse? Is that
Humorously
what you
enough,
do? You're going
in
down
my
Interstate
vehicle,
10 in reverse?
reverse, you push forward on the lever, you want to put it in drive and pull back. I don't know.
I need this to be converted to something in writing. So, fine. Okay.
Ellie's printing a copy.
Ellie's printing it off, Judge.
Well, I don't find. You do too.
We're just gone from the galleries.
You and Jimmy.
All right. So this is a 12-step program. What they're saying, he's gone through 9 steps. What about, and I'm not really familiar with what steps 10, 11, and 12 are.
Yes, Judge.
Since I've never really seen what those are. I don't know what that is. What are they? And it's obviously not part of the inpatient. So is that right?
I would
Is it
suspect
an outpatient or something?
outpatient aftercare that he's doing.
Can I find out what that is? Can anybody, real quick?
If you hand me the computer, I'll find it real quick. Look for you.
Okay, it says, and completed his 8th and 9th step amends process as a sponsor and continues to utilize sponsor upon discharge, successfully completed treatment episode on April 8th. So 4th and 5th step. And 12 steps that covers the program. I just need to know what's
next.
what steps are still required.
So it's,
If,
sorry,
yes, ma'am, go ahead. Do you know?
it's a 12-step process. So like AA.
I knew that.
Well, it's
What
like,
are they?
they're the,
What's still left?
so he'll go to AA meetings and that's part of their step process. So he made amends and then the last few steps, he'll continue working with a sponsor to complete, last 12 steps of recovery.
Right. And Judge, the last step is kind of a continual step, which is that you essentially will eventually become a sponsor and sponsor other people and serve the process of sponsoring other people. And that may have been what you just said, essentially.
This is where the hearing shifts from simply discussing treatment to evaluating long-term responsibility. The court isn't just asking whether the defendant completed a program, it's looking at whether recovery will continue after leaving the facility. That's why the conversation about the remaining 12-step process and ongoing sponsorship matters. From a legal standpoint, appeal bonds often come with strict conditions because the court must reduce the risk of future offenses while respecting the defendant's rights during the appeal process. The judge is clearly trying to determine whether this rehabilitation is genuine and sustainable, not just something that ends after 90 days.
Yeah,
All right.
probably sound better.
Okay. All right. What else are you asking on this?
Judge, we're just asking that you, as a practical matter, you set an appeal bond, he posted the appeal bond and went and did the 90 days that you asked him to do. So now we're asking the court to maintain that appeal bond, I guess is the best way to say it. Chris Romano has the bond. He will do interlock or scram or whatever you want to do on that front.
Of course, we objected whenever this happened. We still object because he was on probation out of misdemeanor court when he committed this offense for DWI third. And so
Here's what we're going to do is I'm going, I agree with the concerns of the state. I'm going to release you on this bond. You must complete timely the full 12 steps in the recovery program that in this intensive residential treatment plan that you attended that still are required of number one. Did I set a bond amount?
You did,
Yeah.
Judge.
Okay.
He posted, I don't know how it works because he had to turn himself back in. So I don't know.
Revoke the bond yesterday.
Oh, okay. So,
Release it
okay.
in order for him to get back into custody.
Okay. I got it.
That's
I
fine.
got it. So he'll have to repost that bond, I guess.
The bond shall be reposted. You shall not operate a motor vehicle at all. Number one, find that you drive a car, an automobile, or any mobile device that's on the street, whether you're intoxicated or not, it will be a violation of your bond. Number two is there's no alcohol. And the scram device, I guess, is what we'll use for that.
That's fine, Judge.
And trying to think of some other terms because I want to ensure that I know if you've got a scram device, but do we have something that can show if there's alcohol in the system?
That would
That's
be
what the scram
The
story
scram
is.
will
Yes,
do.
sir.
What other conditions?
Judge, that's the main problem is, he hasn't had any other criminal history that I'm aware of.
No.
It's just been the
No,
driving while
but this is-
intoxicated, so.
but this is serious.
Yes, sir.
You had that car stuck on the stop on the freeway. It's a 4,000-pound missile. And you didn't even know what planet you were on. But this has happened before. You didn't fix it. Here you are. And you're supposed to be a role model in the community as a business leader, sir. This is not setting a good example. Fix that, please.
Yes, sir.
Okay.
Yeah.
For the safety of yourself and all others.
Yes, sir.
Are there any other conditions from pre-trial services that we need to?
Possibly home confinement, if you want him to stay at home and not go anywhere whatsoever.
Judge,
That way there's no issues about him traveling.
Well, a GPS device will show where he is.
Yes, sir.
And I want you only to go from home to work in the most direct route possible. You can go from home to a hospital if you need medical care. You can go home to a place for food if you need food, and home to church, religious.
Worship.
Mass or worship and all of this is the most direct route possible, and to and from the attorney's office.
and then also AA meetings, Judge, or outpatient.
Well, if
care.
it's required,
Yes.
yeah, he's got to get to that, and he can't fly. So you would have, if you're at Alcohol Anonymous or other programs that are part of this recovery process, you are allowed to go there to and from in the most direct route possible. But again, unless you walk to, you can't drive a vehicle. Somebody is going to have to operate a vehicle. I want to review it in 4 weeks, every 4 weeks, to see how things are on this, because it's intensive, but it deserves attention. Constant attention by the court.
The judge's final decision reflects a careful balancing act between accountability and rehabilitation. Instead of simply approving or denying the request outright, the court imposes a long list of conditions designed to protect the public while giving the defendant an opportunity to remain out on bond during the appeal. No driving, continuous alcohol monitoring, restricted travel, mandatory recovery meetings, GPS supervision, and regular court reviews all serve one purpose: making sure progress continues under close judicial oversight. These kinds of highly structured release conditions are becoming increasingly common in cases involving repeat alcohol-related offenses because they allow courts to monitor compliance while minimizing potential risks to the community.
Are you able to follow all these, sir?
Yes.
Okay. Anything else on this?
Okay.
State and probation?
Yes, sir.
Thank you very much, Reverend Sasser. All right. Christopher Smith? The- Add on. Okay.
Thank you.
You follow it?
It's just my home. They use 8,000.
Normal rip?
Yeah.
Can't appeal a motion.
All right, we have one more matter. It is in the matter of Christopher. Is it Joseph?
Yes.
It's yeah, this writ is misspelled. And Houston Smith. And that's you.
Yes, yes, sir.
And Mr. Gertz is here, is your attorney, and the state's attorney is present. There is a motion or an application for writ of habeas corpus requesting a reasonable bond with the inference that the 800,000 was not reasonable. At least one man's opinion says that. Let me look at this circumstances. You know what I need to
There.
public safety report?
Look.
I've got a public safety report here.
Thank you, Ellen.
You're welcome.
Good move, quickly.
And the people too, just put it on the website, please.
This is all he's been ever arrested for?
Yes, Judge.
That's true.
Yes.
Yes.
You can speak up. Okay. Sometimes help me on the. All right, generally, bonds are set based upon criminal history and circumstances of the offense. And then other circumstances become an issue. That is, if a bond is going to be posted, the ability to follow up with the requirements of a bond. Where do you live? I know where you're residing now, but do you live in Groves?
No, sir. I live in Needleland.
You previously lived in Groves.
Yes, sir.
I grew up in Groves. This is not what Groves stands for. All right. I think I see here why. Imagine who set this bond originally.
Judge Sharon, Judge.
The room. I see why he would have set this. According to the probable cause affidavit here, law enforcement obtained warrants to get certain accounts of that you were associated with to something called KIK Messenger, which I'm not real familiar with. But what they recovered, the police recovered, was a large amount of what they claim is child pornography that was associated with you here. The probable cause affidavit states that the writer, which is Detective Perkins of Needle PD, observed 40 images and videos depicting child pornography, 31 of the videos depicting children being sexually assaulted. Further, according to this statement, the writer, Detective Perkins, the author of this probable cause affidavit, observed the suspect, you, to have uploaded photographs and videos of yourself to the account. And he was able to verify you by comparing the videos to your driver's license. Also, and probably the most disturbing part of this, I also, according to the detective, it was observed that you have communicated with other individuals on KIK, this system, information system, about your sexual fantasies, which included sexually assaulting and murdering infant children. Can you explain that?
Judge, I'm going to ask him not to answer that question.
Oh, well, anything else?
No, other than I don't even know if the bond is sufficient as it is. But
This hearing has now taken a dramatically different turn. Unlike the previous case, where the court focused on rehabilitation and whether strict supervision could safely allow release, this matter centers almost entirely on public safety. It's important to remember that the judge is discussing allegations contained in the probable cause affidavit, not making a finding of guilt at this stage. Even so, those allegations are serious enough that the court is evaluating whether the existing bond adequately protects the community. The judge explains that bond decisions aren't intended to punish someone before trial. They're meant to balance the defendant's legal rights with the risk of danger, flight, or future criminal conduct. Based on what has been presented in court, the judge concludes that lowering the bond would not sufficiently address those concerns. What do you think? Should courts place greater emphasis on the seriousness of the alleged conduct when deciding bond, or should financial conditions be reduced whenever a defendant argues they cannot afford them?
One of the most disturbing things I've read in my career. And I've seen it all, I thought. And number one, child pornography continues to be abusive to the child. It continues to victimize children when it's out there. Child pornography is bad enough in its very essence. But when someone professes to, professes sexual fantasy of sexually assaulting and murdering infant children, that puts it into the potential harm and jeopardy of others in a new light. I don't think, and I've been a part of, from the Jamesburg murders to all types of crimes, but I don't think I've ever read such a horrifying and concerning statement about someone's thoughts, a human being's thought that murdering children would be amusing. Well, that's the inference. $800,000 is, I'm not lowering it. Judge DeRuin, I find, based upon the circumstances of this case, a fair determination. But if you happen to be able to post this bond, we have to have a hearing so that conditions of release would be appropriate based upon these circumstances, which would be a long list plus a list that would include all thoughts I would have to ensure that the safety of children could be preserved if you were released. And it would include at least home confinement, no access to internet. Are you married or single?
I'm married.
Sir?
He's married, Judge. Yes.
Any children? Do you have any children? Okay. Do you cohabitate with your spouse? Are you living with your spouse? He's down.
Oh, he went out on his first shot.
Oh, go ahead, get him now.
Yeah.
On his face.
Emergency medical services.
Radio. Louise, please.
No.
He passed out.
Just relax.
Check the radio.
Thank you. Can I get up? That's good. Don't get up, just sit. Just sit. Start on the floor. Sorry, I apologize. You sit right there.
Where's he bleeding from?
No,
He keeps his head up.
his face first, Judge. Luckily he didn't do that, but he hit his face first. So.
Need some medical services. Thank you. Yeah, he's bleeding.
Yeah.
From face wound. All right.
The jury.
All right, we are in recess on this matter right now. Thank you.
Today's proceedings showcase two very different approaches to judicial decision-making, each shaped by the unique facts presented in court. In the first case, the judge recognized the defendant's efforts toward rehabilitation but made it clear that continued freedom would come only with strict accountability. Rather than granting unrestricted release, the court required ongoing treatment, alcohol monitoring, GPS supervision, travel limitations, and regular reviews to help protect the public while the appeal moves forward. In the second case, the court considered the allegations described in the probable cause affidavit and determined that the seriousness of those allegations justified leaving the existing $800,000 bond in place. The judge also explained that, if bond were ever posted, extensive release conditions would be required before any release could occur. Finally, the hearing came to an abrupt pause after the defendant experienced a medical emergency in the courtroom, prompting an immediate recess so medical personnel could respond. Cases like these demonstrate how judges must carefully weigh legal standards, public safety, and individual rights, while making decisions based only on the information properly before the court at that stage of the proceedings. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping court